President Zuma could find out as early as tomorrow whether he might go on trial. This after the Constitutional Court dismissed CASAC's application to delay prosecution's boss, Shaun Abrahams, from announcing the decision. We're now joined by veteran journalist Karyn Maughan from the Financial Mail. Good evening and welcome to the SABC.
Oh, it's fantastic to be here. Thanks for having me.
With a twinkle in your eye. Now, you're going to take us through just how we find ourselves here. The official figure that was released a couple of days ago was 15.3 million rand. And as you saw in that clip there, the EFF puts it as high as 64 million rand. Try and help us make sense of the rands and cents.
Essentially, the 15.3 was solely in relation to President Zuma's attempt to fight off the DA's application to review the decision not to prosecute him, the so-called spy tapes litigation. We know this because the question was put in terms of legal costs since the 1st of May 2009. Now, on the 1st of April, the decision was made by Mokotedi Mshe to withdraw the Zuma prosecution. That was subsequently announced. So from the 1st of May, the DA was really fighting to review that decision, and that included fighting, NPA not wanting to hand over the spy tapes recordings, all those legal processes that eventually culminated in the North Gauteng High Court making a decision upheld by the Supreme Court of Appeal that former President Jacob Zuma should be prosecuted for corruption. And that's what that 15.3 million is in relation to.
Now, if we go back to even before 2009, there's a lot of litigation that the president or the former president was involved in, again at the taxpayer's expense.
Well, this is exactly the point. I mean, with Advocate Ben Winks, who's been very involved in trying to ascertain through promotion of access to information requests and going through parliamentary questions, we were able to ascertain that the total cost, Bongani, of President Jacob Zuma's attempts to avoid prosecution in fact amount to 32.4 million rand. Now, this is in relation to him challenging the search and seizure warrants that were used to raid his home and the homes of his lawyers so that they got these thousands of documents on which they based their case for corruption, racketeering, fraud, tax evasion, that entire case. It involved his challenge to the mutual legal assistance application that was brought to Mauritius, where they wanted these crucial documents that resulted in the conviction of Shabir Sheikh, Zuma's financial advisor, including the so-called encrypted facts. The former president fought that, lost in the court. It also includes the much maligned Nicholson judgment, in which he said the NPA is not listening to my representations because they're on Mbeki's side. He's manipulated the prosecution. Nicholson making that damning ruling that cost our former president Mbeki his job. He was recalled after that, and subsequently that was overturned on appeal. Now, the important thing for people to remember is that pretty much all of these cases, maybe not in the outset, but in the final analysis, Zuma lost. But taxpayers paid 32.4 million rand to fund litigation that, on analysis, seems to have been unwinnable from the start.
I mean, what's also incredible was that quite often, in a number of instances, he would pursue litigation and then at the 11th hour concede that, in fact, he shouldn't have done so.
Well, this is exactly the point. And the North Gauteng High Court made a statement to that effect in the Nkosana case, where, this huge 17 million rand golden handshake is given to the former head of the NPA, Mxolisi Nkosana, with the apparent motive of making him go away because the president, on his version, feared prosecution and very much believed that Nkosana was going to prosecute him. And the court said, we are alive to the former president's legal pathology. We see what happened in Nkandla. We came on the steps of the court, on the Constitutional Court, with his lawyer saying, actually, this was a mistake. I should have abided by the public protector's remedial action. We saw the same thing in the spy tapes case in the appeal court, where after 8 years of legal fighting, lawyers for the NPA and the president turned around and said, actually, we were wrong. It was an unwinnable case. So, the tragedy is that this is taxpayers' money in a country where we have profound issues of inequality, profound issues of poverty. And there doesn't seem to have been a measure to really evaluate why are we litigating on cases that are unwinnable? And why does there seem to be no attempt to control these processes?
If we get to where we are now, the deal I mentioned in my conversation with Lawson Naidoo that the president announced today, I mean, in the build-up to whether or not President Zuma was going or whether he would stay, it seems this was one of the key concessions Ramaphosa had to make. The idea that the state is going to continue funding for his litigation. What's your response to that?
Well, Ramaphosa's version on this is that the deal was done with Mbeki in 2006. But when Julius Malema, the EFF leader, pushed him on what's the policy here, he couldn't give an answer, despite that being part of the EFF's written questions. And I think Julius Malema was right to get a bit upset about a failure to answer
2 weeks ago.
Exactly. Now, I think that this matter is ripe for legal challenge. The DA has already said it's going to want to bring an application of some sort to force former President Zuma to pay that 15.3 million rand spent on the spy tapes cases. But I think, there are instances, Bongani, in which the state has not funded the legal costs of officials accused of crime. For instance, in the Anu Lemoore case, those police officials applied for state funding and the judge said, thanks for coming, but no. In the Nokuthula Simelane case, where this young woman was allegedly brutally murdered by apartheid police officers, those police officers have not gotten funding, and her sister has gone to court to try and get them funding. So I think we need to see this deal, see the legal, the legal terms in which it's been phrased and what law it bases itself on. And I think it's ripe for a legal challenge to say we are constitutionally entitled to be equal before the law. And if some of us who are politically powerful are allowed untrammeled access to state funds to fight useless battles, then that's not appropriate. It's not constitutional.
But we know are not winnable. Karyn Maughan, thank you very much for your analysis and your insights. Stay with us. There's more after the break.